bill, and House Bill 609 is the House bill. We have a House list, voting list, and a Senate bill voting list. So in both cases, finance has moved on an 8-to-1 basis. Yeah, Senator Washington. Okay, why don't we let Stacy explain the bill? She has to explain the bill. Yeah, right. So Stacy, tell us what the bill does, and then we'll.
House Bill 609 and Senate Bill 591, they're Education, Public Libraries, Collective Bargaining, Library Workers Empowerment Act. This bill establishes a collective bargaining process for full or part-time non-management employees of public library systems throughout the state. As a result, the bill repeals provisions of law rendered obsolete by the bill's statewide applicability. The bill only applies prospectively and may not be applied or interpreted to have any effect on or application to the composition of a collective bargaining unit that is in existence on the bill's July 1, 2024 effective date, unless the collective bargaining unit dissolves after that date. A collective bargaining agreement entered into before the bill's July 1, 2024 effective date, or a collective bargaining negotiations that began before the bill's July 1, 2024 effective date. In the packet for the House bill, the voting list number 36, on page 3, you'll see a copy of the Finance Committee amendments. And they essentially, the only thing they do is change the term governing body to funding body. And as that was on page 3 of the voting list 36 packet, I believe, or did I?
Yeah.
Yeah, okay. And as previously noted, the Finance Committee voted 8-1 on these bills.
So we have to make the amendment?
Yeah, well, we just voted. If we're getting it as already amended, so we just vote favorable.
Okay, okay, we have a motion favorable from Senator Augustine, a second from Vice Chair Kagan. Any further discussion? Is this on? Yeah, Senator Gallion.
So how's are we able to propose amendments here? That'd be probably better on the floor since we're secondary. I don't guess we're secondary on this bill.
Correct. So finance has already passed it.
So any, like I've had a few smaller libraries with like maybe some changes that probably better to bring it to the floor.
Exactly, because if we do anything now, then it's going to have to go back and it's weak. I would say if you got an amendment, put together a floor amendment, talk to B&T, talk to, and I think that's the process wise. It's different if we're primary, but when we're second, it's kind of problematic to try to roll as a second. That so
do you know if the finance entertain any, and you may not know this, we'll just figure it out before we get to the floor, but did they entertain any amendment thoughts that ended up failing in committee? Like I know that the Hartford and Cecil libraries have I've talked with them, and Hartford came in unfavorable. They had some concerns, and I think they were looking at potential amendments, but I was just curious if that was offered in finance or not, or
I don't know.
No, I can talk to counsel and see if he has an answer for you.
Okay. Well, I mean, it would show up on our floor system, right? Under.
Yeah.
So I don't think there are. So, okay.
If you have questions, Dave Smolsky said he's willing to come down and entertain.
I'll catch up with some of the members on the floor.
Okay.
Thanks.
Okay. Well, again, if you got a floor amendment, I think that's the best way to handle this one. Okay. Do we have to move amendments, or we just can move the bill?
I think you move it as favorable.
Okay. So we had the Augustine favorable motion. We had a second from the vice chair. Okay. All in favor? The bill is in front of us with amendments. So it's just a straight up vote one way. Do you want to do a roll call? Okay, that's fine. And by the way, this will count for both. Yeah, well, let's go roll call. But it's we both have 591 on the Senate bill, and this will count for both bills. Okay, and House Bill 609 on the. Okay, we'll do a roll call on this.
All right, Senator Kagan.
Aye.
Senator Kagan, yes. Senator Augustine.
Yes.
Senator Augustine, yes. Senator Gallion.
No.
Senator Gallion, no. Senator Watson. Senator Watson, yes. Senator Lewis Young.
Yes.
Senator Lewis Young, yes. Senator Brooks.
Yes.
Senator Brooks, yes. Senator Carozza.
Yes.
Senator Carozza, no. Senator Hester.
Yes.
Senator Hester, yes. Senator Washington.
Yes.
Senator Washington, yes. Senator Feldman.
Yes. So bill passes 8-2. We'll communicate that to the Finance Committee. Okay, another bill that we've got a joint assignment. Let's deal with this. We've got Senator Augustine's bill and Delegate Wilkins' cross-filed bill on the two lists. Senate Bill 937 we're primary on this one. JPR is second, so we need to get this over to JPR. So I'd like to get this one dealt with. Stacy, back to you. Why don't you tell us again what the bill does, or the two bills?
I have no idea why this is secondary in JPR. There is nothing in here. That is the most bizarre, sorry.
I can't, that's a beef for the presiding officer. I just know right now it's assigned to them, so we want to get it
There is
over to them.
nothing in
so.
there that they have to look at, but okay. House Bill 1157 and Senate Bill 937, Grow Your Own Educators Grant Program established. This bill establishes the Grow Your Own Educators Grant Program to provide support to eligible non-certified education support professionals and provisional teachers interested in teaching who pledge to fulfill a service obligation in a high-need school, grade level, or content area in the state in which there is a shortage of teachers as identified by MSDE. Grant funds for provisional teachers are limited to 1/4 of the funds expended. The program is administered by the Maryland State Department of Education, and the program provides grants to local school systems in collaboratives for certain teacher candidates' expenses and program administrative costs. These collaboratives, consisting of local school systems, employee organizations, and approved teacher preparation programs, may apply for grants by submitting plans to MSDE. Beginning in fiscal 2026, the governor is under the House bill as amended. The governor is authorized to include in the annual budget bill an appropriation for the program. And MSDE must report data about the program as specified. So I didn't include the amendments in your packet, but essentially the Senate bill would be amended to mirror the House bill in this circumstance.
Yeah.
For the,
Well, before let's take some questions. And Sarah Augustine, do you want to add anything since it's your bill? And
Yeah, I mean,
yeah,
basically Stacy laid it out. I
Okay.
mean, we're trying to increase our teachers, and we're trying to do that with the support staff who are there. They stay around. It's helping them to get their education along. And we also heard from the conditional teachers, so that was added. That's really what the add was additional information for the conditional teachers and the may instead of the shall.
okay,
Right.
let's go. We'll open up some questions before we take any motions. We'll go to Senator Watson.
Yeah, thank you, Mr. Chair. Stacy, what happens if they do not fulfill their service obligations? Is there some kind of payback or what?
yes, they do have to pay back a certain amount.
All right, I didn't see that in the
Let me
bill.
see here. Get the bill out here.
Of course, my concern is somebody comes, takes advantage of our resources and then skips town and goes to another jurisdiction.
Let's see here. It doesn't actually say that. It just says they have to, they shall perform a service obligation to teach full time. It does not talk about a repayment.
Okay. Is that problematic if we?
I don't think.
A little
Oh, you
back
don't
and
think
forth.
it is?
Problematic.
Problematic to amend or problematic as is?
Well, can I explain a little bit about how the program works here? So it's not like they get reimbursed. What happens under this program is this collaborative finds a cohort of individuals, these paraprofessionals and these provisional teachers, and then they work with an educator prep program and an institution of higher education and a teachers union, and they find this program, they get together, they decide on whether it's a content area, a grade level, a high need area in the state, and then this group of students get funded to go through the educator prep program. At the same time, they continue to be paid and get benefits at the level they were at when they were teaching at the school that they have come from. So it's not like the student has anything to pay back, because the grant program is actually paying the university for their books, their tuition, and their progress through the program.
Any additional questions? Okay, Vice Chair Kagan.
Thank you, Mr. Chair. Along the lines of Senator Watson, I wonder what the analogies might be with, forgive me, I'm having the public health service or other programs. We have other programs where we either federal or state, where we give people opportunities and there's a bit of a sort of Damocles. And so even if the money isn't going to them, I think the idea of some consequences if you don't keep your commitment isn't the worst idea.
Okay, any further discussion, conversations? Sarah Augustine, Washington, you want to weigh in on this whole topic?
Thank you. The costs, the awards are about tuition and books and stipends for the mentor teachers. And then there's costs associated just administering the program. I think that we should vote the bill. We could determine if this plan to the vice chairs, if there are similar programs where there are such provisions, then we could add that provision on the floor. But if we don't do those things in similar programs, like I know we fund AmeriCorps significantly and we don't require any payback. So that just would be my observation, is that if this is consistent with what we do with other teacher training recruitment programs, we should leave it as it is. If there is language that's currently available, that perhaps we can have a floor amendment on it.
Final word before we do so, Senator Gallion.
So with the, I'm just glancing back at the fiscal note to establish the staff and all that, it's starting like 5 million a year, starting FY26.
There's no funding in the budget for it. They stripped the
It's out.
So if
funding.
there's,
It's now to May.
how do you have a program with no funding?
It's in May.
It is.
I mean, the governor can put it in the budget. If
Malcolm,
they-
put your mic again.
So the witness testimony was that if you set up the program, there might be federal funding to fund it. And that was the thought, is why they stripped out the funding.
And with some of the stuff, we spent a lot of time with Kerwin, I thought, dealing with some of this. How does this marry into Kerwin? Is it just kind of like an addition to it or taking a little above? How does that play together?
It works with Kerwin in the same way that we are. Let's just back up even from Kerwin and let's just go back to the fact that we know that we are struggling with a teacher shortage and that this is what this bill is about. I mean, this bill is about our teacher shortage and finding the people who, if we go back to the testimony, who are most likely to stay in the profession as well. So these are people who are already in the school, who are, let's say they're in the classroom, they're aides, they are not, but they have now decided that they want to further their education, but they're from the community. They may be support staff and things like that. So they're from the community. And this program allows for them, and there are federal funds out there that are available, and they talked about being able to access those federal funds, that these people who we're going to lift up, our own constituents, are much more likely to stay teachers because we got a lot of turnover with these teachers. So it's the best kind of way to invest in getting people who are going to stay in the profession and are going to be committed to our locals because they're from the local. They're not like a youngster who maybe graduated and got a job as a teacher, which we find happens from some other area or whatever, and they come in there and they're like, oh my gosh, like, they're trying to hold on. They're really not as vested because they're not from the community as much. And there's a lot more turnovers, a lot more churn. That's what this is about. I mean, this is about those people, and this has been proved out kind of across the country that they are much more sticky, which is why there is federal money that's available for it. That's what this bill is about.
All right, good, thank
you.
Yeah. Just for what it's worth, the House bill, that we have here, it did pass 126 to 12 there, or 12, but it wasn't like a party line vote or any kind of thing. But okay, so the first action we'll take some more questions, would be to amend the Senate bill to conform to the House bill that's out, and then we can vote with one vote, both, if that's what we do. But before we do that, before we take motions, I just want to get questions on the table. Senator Brooks and then Senator Washington.
All right, thanks, Chair. Stacy, so looking at the bill, it says in awarding a grant, the department shall take necessary steps to ensure that no more than 1/4 of expenses are awarded. So that's if we're concerned about somebody, not fulfilling the obligation.
This is for provisional teachers, so this impacts two groups. One is your paraprofessionals. Those are individuals who aren't certified teachers. They assist the teachers in the classroom and they help with other things around in the school. And then you have provisional teachers that are actually teaching at the moment, but they don't actually have like a teacher certificate, which qualifies them to teach. So I think the intent of the program in general is to encourage these paraprofessionals who are in and around the school to move up in the career, so to speak, by becoming actual teachers. And so they want the majority of the funding to go to those individuals because provisional teachers are already doing it, but we want to get them moving too. But again, the intent of the program was mostly for these paraprofessionals to move up in the education profession.
Okay, Sarah Washington.
Thank you, Mr. Chair. And that's why this Grow Your Own works really well. It's less likely for people to move away in contrast to, as I said, AmeriCourse. I don't have a concern. I think that's a good program, but we do support, or we have supported, Teach for America in a similar way. And the retention rate is a lot lower and people do teach for a couple of years and then start a nonprofit or go move somewhere or run for office. There's a number of things. Whereas these Grow Your Own, these are people who are already living there and they're already working here. So this is a good investment and we'll get a better return. So that would be my introduction to a motion to adopt the amendments to conform the Senate bill to the House bill.
Okay, we're going to go to Vice Chair Kagan, but Sarah Washington moved the amendments to the Senate bill to conform it to the House bill. We have a second from Senator Augustine, so that's in front of us. We'll next go to Vice Chair Kagan, had a question.
Thank you, Mr. Chair. I'm in the House bill and the amendments to House Bill 1157. I'm not finding them in the packet and it's not what was just handed out. Am I missing
Correct.
something?
There's no amendments because we're getting the third reader of the bill. They're in the bill.
Thank you.
Okay, any further discussion before
But
we?
what that
sure.
means is just if anybody's in their system, you shouldn't be looking at the Senate bill because
Right.
that's not what we're voting on.
Correct, and we're about to
Just
conform the Senate bill to
Anybody
that
who's
House
watching
bill.
at home.
Correct. Okay, well, since, there's some discussion, we have the motion. Let's do a roll call and then we'll do the same thing on the underlying bill. And so this is just on the amendments to conform the Senate bill to the House bill that we have in our possession.
So,
From the House of Delegates. So Lemoria, this is just again.
sorry,
Yes,
before
Yes.
we do this, I'm sorry. I think Senator Watson's point was really important. And I am not looking to mess with the bill because we do have a desperate need for new teachers. And I don't want to craft ideas on the fly. Stacy, I'm wondering about uncodified language that would not mess with the concept of the program, but asking for the percentage of people who do drop out, move out of state, not comply after we invest in them, after we give them free money, free education. And so we can remember to look for it and see whether it's working or not. What did you say? Of course, which will take them 2 seconds. Again, it doesn't change the program.
okay, well, you can answer that. Again, this is one where at this point, I would suggest that you can talk to the sponsor, you could talk to Stacy, we can talk to the House of Delegates. That could be a floor amendment, or of some sort. I don't want to do this on the fly right here unless there's a real, Sarah Augustine, it's your bill.
Move the bill as it is, and I think it's a great bill. I mean, this is not new, this is not novel, this is not different. This is happening all across the country.
Which other states are doing it just like this? When you say it's happening all over the country, do you have the list of states by any chance?
I don't have the list of states in front of me, Senator, but I would be happy to get it for you on the floor. And if you want to try to amend it on the floor, you can absolutely do that if it's not sufficient for you.
Okay. Thank you.
I just feel like we're getting into the timeline of sending bills back to the House without it being greased, if you will, and that's, so it's still doable. I just rather move the bill along candidly. And yeah, Senator Washington.
Same, and I'm very uncomfortable with putting this type of stipulation on this program that is targeting lower income individuals that are working towards their certification when we don't have similar language in, Teach for America funding that we give or any of the other programs. So I want to be cautious about, placing restrictions and language on one population that we're not doing for others.
Senator Washington, that is a totally valid concern. We do have language. I remember from last term before, when there have been exactly other reports and programs, for sure. But that's fine. Yeah, just a report on, are people flaking out or are they doing it? That's all. Not, anyway,
Senator Watson.
Since I started this, there is a piece in the bill that talks about collecting data on teacher candidate status and retention. Just moving forward, and I'm going to support the bill, but moving forward, there's got to be a little more efficacy to this thing. But if there's a service requirement, then that requirement has to be served. And if it's not served, then that's money that the state is giving to someone who's not going to perform. And so in the future, I'm going to be kind of looking to make sure, we have those bounds in place when it comes to these types of bills. I agree with what the bill is trying to do, 100%. So I'm good.
Okay, right now we have an amendment and then we had a motion favorable on this, conforming the Senate bill to the House bill. So we'll do a roll call on that and then we'll take up the bill.
All right, Senator Kagan.
Aye.
Senator Kagan, yes. Senator Augustine.
Yes.
Senator Augustine, yes. Senator Gallion. Senator Gallion, yes. Senator Watson. Senator Watson, yes. Senator Lewis Young.
Yes.
Senator Lewis Young, yes. Senator Brooks.
Yes.
Senator Brooks, yes. Senator Carozza.
Yes.
Senator Carozza, yes. Senator Hester.
Yes.
Senator Hester, yes. Senator Washington.
Yes.
Senator Washington, yes. Senator Simonaire.
Yes.
Senator Simonaire, yes. Senator Feldman.
Yes, okay, is there a motion on Senate Bill 937 as amended? Yes, and this vote, since both bills are now in exactly the same posture, this vote will count for both bills.
You're not
Oh.
amending the House bill, you're only amending the Senate bill.
No, I'm saying, but this vote, the vote will now count for supporting both bills because, oh, okay. Okay, how about these? We understand that this vote will be on Senate Bill 937 as amended and then the clean House Bill 1157 that are in exactly the same posture. How about that? Okay. Conversation, discussion. Okay, let's do a roll call. I want to make sure, let's do a roll call on this and then we'll move on.
All right, Senator Kagan.
Aye.
Senator Kagan, yes. Senator Augustine.
Yes.
Senator Augustine, yes. Senator Gallion. Senator Gallion, yes. Senator Watson.
Yes.
Senator Watson, yes. Senator Lewis Young.
Yes.
Senator Lewis Young, yes. Senator Brooks.
Yes.
Senator Brooks, yes. Senator Carozza.
Yes.
Senator Carozza, yes. Senator Hester. Senator Hester, yes. Senator Washington.
Yes.
Senator Washington, yes. Senator Simonaire.
Yes.
Senator Simonaire, yes. And Senator Feldman.
Yes.
So those two bills carry unanimously. Let's now go back to the list. Again, we do have a number of cross files. We'll start with the, we were going to start, let's just go down the list. Senate Bill 432 and House Bill 417. Stacy, these are again cross files. Well, there's a Senate list, which is 37 and a House list 36, but these are cross files. So, the same bills are in both lists, if you will.
House Bill 416 and Senate Bill 432. Public schools active shooter safety drills or training requirements. This bill prohibits active shooter drills or trainings in schools from including specified activities that may be traumatic for students or school personnel. It also requires local school systems to notify parents in advance of active shooter drills or training in schools, provide mental health follow-ups to students and school personnel after an active shooter drill or training, and collect data on the effectiveness and psychological impact of the drills or trainings, and report the data to the Maryland Center for School Safety for further analysis. Finally, the bill requires the Maryland Center for School Safety to develop and distribute model content regarding the state's firearm storage laws as specified. There is an amendment in your packet for the House bill list. That's on page 2. And this amendment clarifies that if a concern is raised about a component of a best practice identified by the center for active shooter drills or training, and it doesn't meet the intent of the trauma-sensitive requirements as specified, the center, after consultation with MSDE, has the final say as to whether it conforms to requirements in the law. And second, it requires a local school system to collect specified data in a manner and format approved by the center for research purposes. The list is 36 and it's on page 2.
Okay, again, we're talking about the amendment on the House Bill 416, which is the cross file to Senate Bill 432. Yeah, Senator Kagan.
Thank you, Mr. Chair. First off, I want to give a big shout out to Stacy, who worked with all the parties. Everyone supports this bill. The House bill passed unanimously in committee and unanimously on the floor. And it's really about making sure that active shooter drills aren't traumatic for the kids and basically just sets up guardrails. Everyone supports this important but clarifying amendment about who decides. And so I support the amendment, support the bill.
Do you want to move that amendment to the House bill?
Sure.
Okay.
Move the amendment to the House bill.
Yes. Okay, we got a motion from Vice Chair Kagan, a second from Senator Augustine. Any discussion about the amendment to House Bill 416? Okay, seeing none. All in favor of that amendment, raise your hand. All opposed, the amendment carries. We've got 416 as amended. In front of us, is there a motion?
Favorable.
Favorable from Vice Chair Kagan, a second from Senator Augustine. All in favor of House Bill 416 as amended, raise your hand. All opposed, that bill carries. Let's just then move to the cross file, Senate Bill 432. Are the bills in the same posture now?
Bill.
Okay, so again, Senate Bill 432 on the Senate list is the same cross file. Okay, any motion to move that same amendment onto this bill? Raise your hand. Vice Chair Kagan, favorable. Second, Senator Augustine. All in favor of that same amendment to put on Senate Bill 432? Raise your hand. That amendment carries. Now we have Senate Bill 432 as amended in front of us. Is there a motion from the sponsors? Senator Kagan moves favorable. Second from Senator Augustine. All in favor of Senate Bill 432 as amended, raise your hand. Okay. Let's go over and back on the House list. Delegate Atterbury's bill. Again, B&T is second on this, so we want to get this over to B&T. This is House Bill 903, Delegate Atterbury, dealing with education for special ed students, et cetera. So Stacy, again, House Bill 903 over on voting list 36.
House Bill 903, Education, Access to Attorneys, Advocates, and Consultants for Special Education Program and Fund established. The bill establishes the Access to Attorneys, Advocates, and Consultants for Special Education Program and Companion Fund, both administered by the Maryland Volunteer Lawyers Service. The program directs resources and services to eligible students to provide access to legal, advocacy, and consultant services. Eligible students are those with a disability whose parents have a household income not more than 150% of the Maryland Legal Services Corporation income guidelines and made at least one attempt to resolve a disagreement with a public agency regarding the child's special education services or program. Beginning in fiscal 2026, the governor must include $2 million in the fund in the annual budget bill. There is one set of amendments offered by Senator Hester beginning on page 4 of your House bill list packet. And these are consensus amendments with the House. So they change the administrator of the program to the Maryland Legal Services Corporation from the Maryland Volunteer Lawyers Service. They changed the advocate and consultant training requirements to those that were passed by the Senate in Senate Bill 797, which essentially focuses on seeking qualified individuals and ensuring individuals have knowledge of federal and state special education law and procedures versus training lawyers, advocates, and consultants kind of from scratch. It requires MSDE to administer the fund, and it changes the fund amount to $1 million as approved by the Budget and Tax. Just a note here, there is a disagreement between the House and the Senate as to the amount of the fund. Council and I have talked about this. The Senate's changing it to 1 million. The House is changing it to 2 million. Once the Budget Committee meets and confers and agrees on the amount, we will concur with whichever bill is the correct amount of the fund. So
For Hester, since you, this consensus amendment as described by Stacy, would you want to add anything?
I just like to thank, Stacy and committee council in the House and the president's office for working on this.
Okay, before we do, Vice Chair Kagan has a question before we take up that amendment. Oh,
Trying to turn off my.
oh, okay. Okay, would the sponsor of the amendment want to move that amendment? Okay, we have a Hester sponsor amendment favorable, second from Senator Augustine. Any discussion on the amendment from Senator Hester? All in favor of that amendment, raise your hand. All opposed, that amendment carries. We now have Delegate Atterbury's bill, HB 903 as amended in front of us. Any discussion? Okay, motion. Senator Hester, favorable, second Senator Augustine, all in favor of House Bill 903 as amended, raise your hand. All opposed, that bill carries unanimously. Okay, let's, I'm sorry. Okay, yeah, let's, okay, let's, because I think the Augustine Love Bill 11, I think it's going to take a little more conversation. Why don't we get to these other two cross files and then we'll take up the 1101 and 650, Senate Bill 653, 1101 last. So there's two other bills, both with cross files on the two lists. So we've got we got Senate Bill 922 and Delegate Adams' bill, House Bill 1231, which are cross files with one another. Dara, why don't you tell us what those two bills do? Okay. Again, Senate Bill 922 and House Bill 1231.
Never mind. You're right. So House Bill 1231 and Senate Bill 922, Natural Resources, Fisheries, Oyster Management. As drafted, Senate Bill 922 repeals a prohibition against the Department of Natural Resources taking any action to reduce or alter the boundaries of specified oyster sanctuaries until the department has developed a specified updated fisheries management plan for the scientific management of the oyster stock. The bill also authorizes a person to dredge by powerboat in the public oyster fishery area in Eastern Bay and Queen Anne's and Talbot counties. There was one amendment to Senate Bill 922. It's on page 9 of your voting package for voting list number 37. It would bring Senate Bill 922 in line with HB 1231's current posture before this committee. The amendment would remove the power dredging provision. I should also add that with this provision removed, DNR has removed their opposition to this bill.
Okay, so there's no DNR opposition to this bill anymore with this amendment. Any questions of Dara on, again, well, let's focus now on Senate Bill 922 that has this amendment that was described, and this amendment would conform it to Delegate Adams' bill, House Bill 1231. Any discussion? Okay, is there anybody want to move this amendment? Okay, Senator Carozza moves the amendment. Is there a second from Senator Gallion? All in favor of the amendment to Senate Bill 922? Raise your hand. All opposed, the amendment carries. We now have Senate Bill 922 as amended in front of us, and this will also count as a vote for House Bill 1231 clean. Okay, everybody understands that? Okay, the bills are in the same posture with that amendment. Okay, all in favor of these two bills, Senate Bill 922 and 1231 on the House side? Yeah, we need a motion. I went through this yesterday. Skipping that beat. Okay, Senator Gallion moved favorable, second from Senator Carozza on these two pieces of legislation. All in favor, raise your hand. All opposed. That bill carries, those two bills carry unanimously. Let's now go to Senate Bill 1028 from Senator Wallstreicher and House Bill 1168 from Delegate Kaiser. Dara, back to you.
Mr. Chair, if I could call up Adrian Gardner just in case there are any.
Okay, Mr. Gardner, you'll come up just for questions, okay? And why don't you start and then Adrian could be here for questions, okay?
House Bill 1168, Senate Bill 1028, Human Remains, Alkaline Hydrolysis and Natural Organic Reduction, Green Death Care Options Act. There is an amendment to Senate Bill 1028 on page 10 of voting list number 37, which would bring Senate Bill 1028 in line with the current posture of House Bill 1168. The bill requires the Office of Cemetery Oversight in conjunction with the State Board of Morticians and Funeral Directors to adopt regulations establishing a process for regulating crematories that use alkaline hydrolysis, reduction facilities that use natural organic reduction, and registered reduction operators. The bill conforms the definitions of cremation and crematory across the business regulation, health general, and health occupations articles. The bill exempts a funeral establishment, crematory, or reduction facility from the requirement to maintain a body in a manner that provides for complete coverage of the body and prevents leakage or spillage during placement inside a contained chamber or vessel without an external visual exposure during the process of alkaline hydrolysis or natural organic reduction. The bill also makes several prohibitions on the use or disposal of soil remains produced by the natural organic reduction, including sale or resale or use for food or livestock. The bill makes a number of conforming and technical changes. The amendments which are to be made to Senate Bill 1028 would remove references which would have made licensed funeral establishments responsible for handling soil remains from natural organic reduction. They would also clarify that disposition of soil remains on private property require the written permission of the surviving owners of public record. We would require regulations to meet certain requirements and would add a provision regarding notice to the Department of Veteran Affairs and transfer of unclaimed soil remains of a veteran or an eligible dependent. Again, these amendments would bring Senate Bill 1028 in line with House Bill 1168.
Yes, Senator Caruso.
I just would like to better understand, those amendments came from where?
Good morning, Senator Croza. Thanks for the question. They came actually in collaboration with.
Adrian, first of all, here, get that mic a little closer to you.
My
And then tell us who you are, just so.
My apologies. Good morning, Senator Croza. My name is Adrian Gardner. I'm with a company called Green Legacy that's trying to help establish one of these businesses in the Montgomery County area. And I've been working extensively on the bill with the Maryland Association of Funeral Directors and Morticians, with the Office of Cemetery Oversight, with
That answers, so it is in coordination with the funeral directors. Okay.
It has been, and they withdrew any opposition to the bill after working through those amendments.
Thank you.
Okay, any other questions for Dara or Mr. Gardner? Okay, so we have this, yes, Senator Washington.
I guess this is on the bill, on the issue. I want the concept, I want the process to move forward, but I just want to say to our committee that next year, we have to pull alkaline hydrolysis. It is not cremation. We have a studies bill that I've made some amendments. So simply amending this process into the cremation is sloppy, and there are water quality, soil quality issues that have not been interrogated and are currently not within the portfolio of MDE to permit. So I do have a concern that we also, and I just want to ask if there's anywhere in the bill that requires MDE to develop specific regulations around water quality, stormwater disposition of the effluent.
The answer to that question is no, there isn't anything that directs MDE to do that, because it is normally done by the appropriate municipal water authority, and they set parameters for what water quality needs to be before you get a discharge permit. And to your first point though, Senator Washington, yes, one of the concerns that the Funeral Directors Association had was distinguishing between cremation and alkaline hydrolysis. So the bill, I think, does make that distinction. It would allow a crematory to use alkaline hydrolysis equipment, but the treatment of the product of that is called hydrolyzed remains in the bill, as opposed to cremated ashes. And that's so I just wanted to point out that the bill actually does carry the first distinction you were talking about.
I guess I'll ask committee staff. I'm reading that added to the definition of a crematory is hydrolysis.
Can you point to the page, sorry? Oh,
yeah, so I guess it would be in in the definitions. So it'd be.
Oh, so I'm seeing page 3.
What lot? Yeah.
Okay. Yeah, so that I think it's repeated a number of times with the bill. So I'm looking at page 3, lines 18 and 19. And the bill does align the definitions. So crematory means a building, portion of a building, or structure that houses the necessary appliances and facilities for cremation or alkaline hydrolysis. I think this is what Mr. Gardner was speaking to, is that a crematory facility can carry out both of these services, but I think this was the case in perhaps a previous iteration of this bill, that cremation was expanded to include this. Here, cremation and alkaline hydrolysis are two distinct services, and there's different requirements afterwards, but the same facility could do both. I don't know if that addresses your
Well,
question.
so my concern is that a permit to operate a crematory from a environmental, air quality, all those perspectives does not include consideration of permits that it does not consider the emissions or the result, the effluent of the alkaline hydrolysis process. In other words, it seems as though this would become a part of the permit in an existing crematory without an evaluation of of what is done to, of the remains of what is done to a body as a result of that process of organic reduction.
So if you look at leading from the bottom of page 6 into page 7, there is a requirement that a process for regulatory and crematories that provides for registration, of crematory operators, and it includes applications including certification of ownership and identification of individuals who will perform alkaline hydrolysis or natural organic reduction. I don't know if that's
right.
addressing
So
your concern.
again, it's focused on the it's treating it. It looks to be it's treating it as a additional conditional, use from a facility perspective, and then it does not. And I thought I heard you say that responsibility for. It seems like the soil remains or the water remains are not addressed in this. If we're going to, so it's requiring the director. So we have two, so this is why, my bill was complicated. I understand we need to think about it. In the state of Maryland, we regulate these from a operational building licensing. And so the morticians, and they're focused on that. For the crematories and some, there's also the air quality permit to construct, et cetera. So there's also a regulatory framework for dealing with the emissions. I would suspect that we would need both the director to operate it from who's doing it perspective, the morticians and that professional board of who's doing it, making sure they're licensed. But we would also need to ensure that, if you can look, it requires the reduction facility to monitor written verification that the temperature during each instance attains it. So we're asking the operator to write it down.
Sarah Washington, could I just
So, yeah,
ask,
that's just
to,
I'm sorry.
that's okay, because, not that this is relevant to anything we do here. This is a bill that passed unanimously out of the committee and the full house without any discussion, but that's not, we do our own thing. But I just wanted to make sure I know where we're heading with this. Are you looking for an amendment? Are you looking for
would
what?
just like
Okay.
an amendment that would direct that there be regulations specific to the whatever's produced as a result of this process. And I don't need us to put it in there, but that we need to say that there needs to be
Okay,
MDE
Adrian,
regulations.
Okay, I don't have an opinion one way or the other on this one. So
Yeah.
could you guys give us some feedback? And then I think I'd like to get to the Augustine bill, that Crosswell too.
Yes, I just wanted to offer Senator Washington, Mr. Chairman, thank you again. If you're talking about regulations related to soil remains, which is a different process, the bill is very extensive on that. And both agencies have to adopt identical regulations. That's the way crematories are currently regulated now. Both agencies have to adopt identical regulations. But this bill goes further and it says that there has to be testing in place. There are limits to what can be done with the soil remains. With respect to the water cremation, which is a different process, it's not specific about that, but the process is, as you said, there are two things. There's effluent that comes out of the process, and there are ashes that come out of the process. The ashes are essentially treated the same way as in current law. We treat ashes. You can put them on the mantle. You can put them in a columbarium. You can do whatever you know currently. And with respect to the effluent, the only point is the current regulations and the current law doesn't say that you have to get an air quality permit. You have to get an air quality permit because that's the only way you're able to operate that equipment. In this case, the water systems give you parameters that you will have to meet in order to get a discharge permit. And that's where and I think, I just want to be clear that I think that those things are implicitly addressed, but we will certainly I'd come by and talk to you about it if you think that amendment is appropriate.
He said, I guess I'm in a position where I can't support it if it's not. So I asked them, where does the water or the excess go? And he said, in the storm drain. So I just, there just needs to be some entity that is qualified and that we do to check this out. That's all.
Here's what I'm going to suggest. I think, because my sense is there's a lot of support in the committee for the bill. So if we move forward with the bill, maybe you can talk, again, this is not going to be on the floor today. If you want to work on some amendment from floor language, well, I'd like us to have some actual language. I mean, and a floor amendment, so I would suggest we move forward with this, and then you can work with council, Mr. Gardner, and then whoever has got this on the other side. I think this is Delegate Kaiser, just so that, okay, let's do that. Okay, first we need to take up the amendment to conform the Senate bill, Walt Stryker bill, to the Kaiser bill that came out unanimously out of the House. So in Senate Bill 1028, we have a motion from Senator Kagan to conform Senator Augustine's second. Okay, all in favor of this conforming amendment to Senate Bill 1028, raise your hand. Okay, that amendment carries. So now we have Senate Bill 1028 as amended in front of us, and this will count again as a vote on House Bill 1168 clean. And this one, so because of Senator Washington, let's do a roll call. I want everybody to have. Oh, we've got a motion. Yes, did you move favorable? Yeah, move favorable in a second, right. So we'll do a roll call on again, this is going for both Senate Bill 1028 as amended and then 1168 clean, and take the roll call, Lamar.
All right, Senator Kagan.
Aye.
Senator Kagan, yes. Senator Augustine. Senator Augustine, yes. Senator Gallion. Senator Gallion, yes. Senator Watson. Senator Watson, yes. Senator Lewis Young.
Yes.
Senator Lewis Young, yes. Senator Brooks.
Yes.
Senator Brooks, yes. Senator Carozza.
No.
Senator Carozza, no. Senator Hester.
Yes.
Senator Hester, yes. Senator Washington. Senator Washington abstains. Senator Simonaire. I'm sorry. Senator Simonaire, yes. Senator Feldman.
Okay, yes, so it's 9-1 abstention, and that vote will count for the two bills are now in the same posture. So that what? Yes.
Be a co-sponsor on this bill. That's all right.
Can you, since we already took a vote? Yeah, I would say on it, I think we can get a, sponsor amendment on the floor. Okay, let's move on. And the final bills that we're going to take up today and for the week, I believe are going to be Senate Bill 653 and House Bill 1101. And we will turn to Dara to describe those bills, and then Sarah Augustine, if you want to weigh in with appropriate.
Again, if I could call up Jeremy Baker from MDE, please.
Baker, why don't you come on up? And for what it's worth, I think I see Mr. Etten. I know that he indicated that he sent a bunch of new amendments into the committee, but we'll just take that up as we discuss the bill. But we'll start with you, Derek, refreshing everybody's memory about the bill.
So House Bill 1101, it's Senate Bill 653, standing environmental and natural resources protection proceedings, Clean Water Justice Act of 2024. In voting list number 36, on page 7, there is a reprint which includes the amendment which I handed out, which is a standalone document. The reprint begins again on, pardon me, page 8, the reprint begins. And there is also an amendment in voting list number 37, which starts on page 2, which simply conforms Senate Bill 653 to the reprint of House Bill 1101. Separately, there is also an amendment from Senator Washington, which is not included in this reprint.
Introducing that.
There is no amendment from Senator Washington. So, as amended, the bill states that a person that meets the threshold standing requirements under federal law has standing in civil claims arising under any requirement, prohibition, limitation, or condition established by statute, regulation, permit, order, or license issued by the Secretary of the Department in accordance with Title 5, Subtitle 9 of the Environment Article, which deals with non-tidal wetlands, if the requirement, prohibition, limitation, or condition is related to non-tidal wetlands that do not have a continuous connection to surface water, or Title 9, Subtitle 3 of the Environment Article dealing with water pollution control, if the requirement, prohibition, limitation, or condition is related to an ephemeral stream or an intermittent stream, both of which are defined terms under the bill. A person that is standing under the bill may bring a civil action on the person's own behalf against any person or political subdivision that is alleged to be in violation of any standard. The bill establishes notice requirements, and there is a 60-day notice requirement for bringing an action, which is similar to under federal law. A person may not bring an action if the Secretary has commenced and is diligently prosecuting a civil action, or a consent order is entered to require compliance. An action must be brought in any circuit court of a county where the condition, activity, or failure is alleged to be a violation of the standard. The bill also establishes notice requirements relating to consent judgments. Finally, the bill clarifies that a person that meets the threshold standing requirement under federal law has the unconditional right and authority to intervene in a civil action brought by the Secretary of the Environment under Title 5, Subtitle 9, or Title 9, Subtitle 3 of the Environment Article. And this right to intervene does not have the same limitations about relation to non-tidal wetlands with regards to Title 5, Subtitle 9, or being related to ephemeral streams or intermittent streams with regards to Title 9, Subtitle 3. I'll let MDEs speak to this more if they want, but this is due to the fact that the right to intervene and the right to bring an action are two separate rights.
Mr. Baker, do you want to add anything on behalf of MDE?
Thank you, Mr. Chair, Madam Vice Chair, Jeremy Baker on behalf of the Department of the Environment. I think Dara did a very good job kind of, summarizing the bill, but I'm here to answer any questions because I know this is a very technical, complicated bill.
Okay, sir, Augustine, you want to weigh in? And then I'll just ask, since I see Mr. Edna, has he sent you, have you received any amendments?
Not to my knowledge, no.
Okay, I just have to put, ask. Okay, do you want to weigh in?
Yeah, sure. So just to sort of bring us back to what this bill was, this bill comes from the Supreme Court decision, Sackett decision, which changed the definition of waters of the United States. And it created a definition that included only basically surface waters that are always contiguous and connected at all times. And so what that meant was that historically speaking, it extended beyond that to wetlands and streams that aren't always there, but they're still a part of the water systems that we have, of our watershed and of our water system. And the federal law, Clean Water Act, allows for, and has always allowed for, one of the unique characteristics of it would allow for citizens to act, to sue, to be able to be kind of eyes and ears all over the place as it pertains to making sure that we are not having pollution in our waterways. And it's been a very, very effective law as far as helping us to clean up our waterways, which is all it is about. And it's the same thing like all these other things that we do, trying to clean up the bay, trying to clean up everything. That's what it's about. Now, what this law, what this piece of legislation now attempts to do, and it's just been made much more narrow, much more narrow. Now it's just like that right that was taken away on Sackett. We are now replacing that and putting it into place, but within our state law, and making really clear about very specifically what is being replaced, like these particular types of streams and wetlands. So it's much more narrow than what it was before. I think it's it's been really worked out. We've done some additional sort of amending just to make it really, really clear that it is simply replacing that which was not there. If you all remember, when I asked the folks who were, against this, well, how many times have you been impacted by this on the federal law? Because the federal law has been in place. I mean, this is just like within the last year. And I haven't received anything back from them when I asked, like, okay, well, how is this in these particular circumstances? But what's important with this is that this will allow for us to have those protections in that very narrow space. And so I think that this is a really important piece of legislation, very narrow, very focused. Just to keep the conversation going, I'd like to move the amendments. One of the things in here on the Senate bill that we talked about, but I don't see here, was I did say that Senator Smith had asked to be a co-sponsor of it. And Senator Washington had asked me about that too, as well, to be a co-sponsor. So just incorporate that along with the amendments that we put into place that we've worked on and through with MDE to make sure it's really clear. So
so we had a favorable motion from Senator Augustine, a second from Senator Washington. One quick question before we take up the amendment. Then we go to Senator Hester. MDE weighed in favor with amendments in the original hearing. So what's the posture, just so I know on the record? Is MDE favorable, or what?
Yes, we work closely with Senator Augustine, Delegate Love, kind of through this entire process.
Gotcha.
So we are comfortable with where the bill is.
Okay, thank you. Okay, go to Senator Hester next.
That was half of my question. The Office of the Attorney General also was favorable to amendments. Are they now favorable?
I'd have to ask about that. I don't know that they came back after we clarified that part of it.
Do you know what their concern was?
Why don't you can look.
I'll look it
We'll
up.
take a question from Senator Gallion. Yeah.
And then the other half
Sure.
of my question was, there was a ton of unfavorables. It sounds like there was a lot of work done on this bill. Do we know where some of the other folks stand, the builders, the Farm Bureau?
Yeah, I mean, they are still, as you can see with Bob Enton, they're still they don't want to be held accountable. I mean, that's just the bottom line. I mean, but it's our job to look out for our streams and for us to look out for and to provide this opportunity, which again was there before, so that we have these eyes and ears. I mean, so they're always going to be against these types of protections that I think guardrails that are going to be there. So it's far more narrow now, I will say that. And so, but I asked them that question and they were against any of them from before. So that's still going to be their posture, I believe. It's going to be difficult for them to move off of that.
Okay, Senator Gallion, then we'll go to Senator Caruso.
Pardon me, Mr.
Oh, I'm sorry. Yeah, go on.
Just to address Senator Hester's first question in relation to the Attorney General Office amendments. Their proposed amendments had been that Senate Bill 653 should be amended to clarify its provisions and confine its scope to the Clean Water Act's citizen plaintiff provisions, and to clarify that citizen plaintiffs cannot intervene in criminal actions. So that the bill does specify that as their civil actions.
Thank you.
Okay, we'll go to Senator Gallion, then to Senator Caruso.
Yes, I would disagree with my colleague when it comes to certain people not wanting accountability. I think you might have a very few number of bad actors in some instances, but honestly, the majority of the opposition comes from the agriculture community. And, I'm proud to say farmers are known as the first environmentalists. So that's where my concerns are on this. I'm even like treated ditches or wet spots in a field could be considered intermittent streams under this. That just leaves things wide open. And, farmers are already trying to, especially, ones that want to do like ag tours and stuff like that, that invite people onto their farms to try to get that experience. And so people can learn where their food comes from, how it's grown, stuff like that. You could have one person to come on and say, well, look at that water there. And then it just opens up a whole big realm. This is like a trial attorney's dream, I think, having this in. So, I have extreme concerns with that.
Sure.
So again, Senator, this is, if that were the case, how many of those cases have you heard over the last course of so many years that has been the case? Because that was the law just less than a year ago. I'm going to just go back to that. This is not something that's new or novel. The change was that it was a reduction in the opportunity for that standing that occurred like less than a year ago. So can you share with me where these kinds of things have been occurring that you're talking about?
Well, on the flip side of that, can you share with me where there are these bad actors, how many of these issues are arising?
Absolutely, I surely can, because it's not about that. So there's no question about it that there are cases that this law, Clean Water Act, has been extremely successful in helping us to clear up and clean up where this is about pollution. This is about folks who have polluted our waterways. And there have been cases across the country and here in Maryland where citizens have seen where there has been these releases. And I'll give you an example that I think about sometimes. Think about where we have like wastewater treatment and stuff like that. And you're out there. I know I've experienced this. I experienced it not that long ago. You're out and their systems there's a break in the pipes somewhere. They don't know what's there. And some citizen has found it and they choose not to do anything about it. Well, then we need to hold them accountable for that. That's the type of thing where it has really been helpful towards us cleaning up our waterways. What I will say is that this is not something new. This is simply putting something back. It's all that it's doing. It's simply putting it back. It is not something new.
But that level of standing never existed at the state level before, though, correct?
It was at the federal level and it remains at the federal level, except for this very narrow circumstance. And that ability was there, but that ability just for that very narrow circumstance, which is what we are now putting back with this language, which is very narrow. We're simply putting back that which was there at the federal level. And we are putting it in state law because of the Supreme Court, a Supreme Court that has been doing all kinds of things to roll back our protections for our environment. Are we going to protect our environment? Or are we not? So since they have chosen to roll back protections for our environment, we as a state policy body, I feel we should seek to continue to protect our waterways, continue to protect our bay. That's what this is about.
Let's open it up to Senator Carozza, then Senator Hester.
Thank you, Mr. Chair. And I just want to first start by, I'm highly offended by the comment that if you have objections to this bill, that means you're not being held accountable. So I don't accept that. And I wanted to elaborate a little bit on Senator Gallian's comment. When you represent these areas, rural areas, and you actually have these farm families under all kinds of scrutiny, and you have a bill like this that's going to open up lawsuits against these families, it's not the right way to go. We have stringent requirements with the Maryland Department of the Environment and all kinds of other restrictions and prohibitions that these farm families follow. So now we're opening this up with basically lawsuits, which is not the way to resolve issues. If we have issues, they shouldn't be resolved this way. So, the examples that we give are real to our constituents, and I'm very concerned about the impact of this legislation.
Okay, Senator Hester.
I'm feeling rather torn at this moment, representing some, agricultural communities, that also border, with, not anymore, I guess, but like aware of families that border with the state of Pennsylvania. And we heard the hearing was a month ago. We got the voting list last night. I haven't had a chance to read the reprint. So at this point, I just kind of want some time to read the bill. I'm not asking for a hold, but I just wanted to kind of signal kind of where I'm at, and just kind of curious because I fully support I mean, I could talk to you about the Supreme Court for a long time because it's become a political body, which is rolling back lots of different things. And at the same time, I'm just curious, so what happens? If somebody just over the border in Pennsylvania sends a lot of stuff down the river, can we sue them?
And we got to be on the floor here in 5. So I'm more than happy for us to hold this. I can talk to you, Senator Hester, or anybody else in the meantime, and we could try to get there.
Okay. Well, here's what I'm going to suggest. First of all, even if we were to do something on the bill, it's not going to make time to be on the floor today.
Oh, yeah.
But we have a lot of bills in the committee still, and what I'm going to suggest to everybody, in fact, I'm going to ask everybody on Monday around 4:00 if we have a lot of bills, whether it's affordable housing, the Elford, still in the pipeline. And so we're going to meet, you're done for this week, but come back Monday at 4:00 and we're going to continue voting. We can start with this bill. And, and those bills will be on the Monday, probably if we were to pass it. So we're not really, whether we did it now or do something Monday, this bill will not be on the floor till Monday night either way. So I would say, let's take the benefit of some time and everybody's comfortable. And then we'll deal with this Monday afternoon at 4:00. Okay. Hopefully that works for everybody. Again, it's 1 week left in session. We got a lot of House bills we got to churn through. So that's the plan. So you have a great weekend. Nothing after session, but try to be back here at 4:00 and we'll do some more voting. Okay, guys. So with that, we are going to adjourn for today. Okay.